All right. Good afternoon, everyone. I'm Emily Hammond. I'm one of the professors here at the law school where I teach energy law, among other things. And I am so delighted to see so many familiar faces in this room. And it's a real treat for me to be able to moderate this afternoon's panel. I'll introduce our expert from IAEA first, and then I'll introduce our other panelists as we shift over into that portion of the afternoon. And I hope that everybody is making lots of notes on the questions that they'd like to ask in the meantime. So, all right. Well, first we have Anthony Wetherall, who is the head of the Nuclear and Treaty Law section of the IAEA Office of Legal Affairs. And there he provides advice on various international and national nuclear law issues, covering nuclear safety, security, and liability. He also delivers extensive support to member states, such as in drafting national nuclear laws and in conducting trainings for decision makers, policymakers. He previously has also served as the senior lead researcher on Singapore's multidisciplinary nuclear governance project. And he was part of a UK law firm's nuclear law team, advising clients in the context of new nuclear builds, waste management, and decommissioning programs. So a wealth of experience from a variety of perspectives. Please help me make welcome Mr. Anthony Wetherall.
Well, thank you very much for that warm reception. What a great honor and privilege it is to be here in DC and also at this learned institute. And it's really a hard act to follow. It's really an impossible job after the Director General. He was amazing, but also you've all had lunch. So please don't fall asleep on me. But we're going to make a segue back to the non-proliferation regime we heard about earlier by Unit Susanu. Now we're going to focus on nuclear safety and also civil liability for nuclear damage. We have a global nuclear safety regime. We're aspiring to achieve a global nuclear liability regime. And part of these regimes, the legal frameworks are key. And these two subjects are very, very important. They're of global interest and also of global concern. And developments have taken place primarily in the area of nuclear safety as a result of accidents. So in as much as the focus is on protection and prevention of people, property, and the environment, unfortunately, accidents can occur. We cannot take safety as being guaranteed. In no human endeavor is that the case. And from the lessons that we've seen of past accidents, and most recently, the 2011 accident at the Fukushima Daiichi nuclear power plant. We have the 1986 Chernobyl accident. We've seen developments take place with respect to the international legal frameworks. And these frameworks establish a basis to prevent and minimize the risks of an accident and also to mitigate the consequences, the radiological consequences, if we think of emergency response. And there is also a need to think about allocation of loss. And this is where we can turn to civil liability for nuclear damage. And it's with this in mind that I want to now sort of walk you through and identify the relevant international legal instruments. Unfortunately, there isn't just one convention on nuclear safety. There isn't just one convention on nuclear liability, but there's rather a number of international legal instruments. And I also want to then touch upon the role of the IAEA in the area of nuclear safety and liability, focusing essentially on the legal frameworks. With respect to nuclear safety, the Chernobyl accident gave birth to an unprecedented developments with respect to international cooperation. Countries got together in the aftermath of the accident and established new conventions, in particular the Convention on Early Notification of a Nuclear Accident and the Convention on Assistance in the Case of a Nuclear Accident or Radiological Emergency. They drafted this in unprecedented period of time, and this was a reflection of the urgency and the concerns that prevailed at that point in time. These conventions establish an international system for the notification of nuclear accidents and a basis for states to request assistance in the case of a nuclear accident. Conventions, from the perspective of adherence, they're very well adhered to. We have 134 parties at the moment to the Convention on Early Notification and 128 parties to the Assistance Convention. States also decided to adopt the Convention on Nuclear Safety, but it's not covering all aspects of nuclear safety. Here, the focus of the Convention on Nuclear Safety that was adopted in 1994 is on the safety of land-based nuclear power plants, from their design, construction, operation. This is the focus of the Convention on Nuclear Safety. They went a step further. They decided also to adopt the Joint Convention on the safe management of radioactive waste and spent fuel. So this is more the back end. Both conventions are also fairly well adhered to. There are 96 parties to the Convention on Nuclear Safety, and the Joint Convention has 90 parties. A feature of the Convention on Nuclear Safety and the Joint Convention is that they provide for state parties to establish legislative and regulatory frameworks. And this is really then a key element of the nuclear safety framework, that is establishment of a system of regulatory control. And that's at the heart of nuclear safety, to ensure that there is a system of control, a regulatory body or bodies, independent, with resources, with clear legal authority, and the functions of authorization, inspection, and enforcement. And this is what is foreseen within both conventions with respect to their particular scopes of application. Another key aspect of the two instruments is that they're referred to as incentive conventions. We heard earlier about the verification, the system and mechanisms for enforcement in case of non-compliance. In the area of nuclear safety, and at the heart of these two conventions, is the peer review process. They don't rely on mechanisms for sanctions and non-compliance of their parties, but rather the peer review process, which are triennial meetings of the parties, and through which the parties prepare national reports on how they've implemented their respective obligations, and they present these reports and receive questions and be prepared to answer them as well. And this is the peer review process of the Convention on Nuclear Safety and the Joint Convention. The accident in 2011 at Fukushima Daiichi nuclear power plant reinvigorated the parties and member states to reconsider nuclear safety. It was a reminder, unlike Chernobyl, which gave birth to the four conventions I've mentioned, Fukushima Daiichi nuclear power plant accident was a reminder, and the focus, as reflected in an action plan on nuclear safety adopted through the policymaking organs, was on strengthening the effectiveness of the existing conventions. And that is exactly what happened. And the peer review processes of the two conventions were strengthened. There was an enhanced focus on transparency and openness. Also, in the context of emergency preparedness and response, there was mechanisms as well put in place to strengthen the emergency system that exists. And we've also seen increasing levels of adherence to the conventions. Let's just focus on civil liability for nuclear damage. This was always an issue of concern. Already in the 50s, it was a concern of the nascent nuclear industry at the time, and there was a need in recognition of the extreme magnitude of nuclear accidents, could be transboundary, may impact people, property, and the environment. It could affect people in different countries, and there could be damage. It could be latent, long-lasting, and there could be challenges with respect to the causality, proving that the damage originated as a result of the accident. Countries at the time, including here in the United States, developed their own national legislation reflecting some basic principles. There are 7 basic principles of nuclear liability. One is the strict liability, no-fault liability of an operator of a nuclear installation. And this reflects the scope of the convention. We're focusing on nuclear installations and also the transport of nuclear material to or from a nuclear installation. This operator is strictly liable and exclusively liable. This is another key aspect. And this liability is for a minimum amount as foreseen in the particular conventions that have been established. And this liability would be assured primarily through insurance, but there are also other means as well. This is just some of the basic principles that I've mentioned. There are 7, which are reflected in the international conventions. And the conventions that were established first in the 1960s were strengthened in the 90s. And currently we have 4 conventions. And within these conventions, we can classify them as the Paris regime because they have been adopted. It's primarily the Paris Convention on Third-Party Liability was adopted under the auspices of the OECD NEA. This is more of a Western European regional regime. We also have instruments that have been adopted under the IAEA's auspices. In particular, we have the Vienna Conventions, one from 1963, and then the protocol to amend that convention from 1997. There was also adopted as a consequence is the 1988 joint protocol, which creates a link between the Paris Convention and the Vienna Conventions. In 1997, there was also adopted the Convention on Supplementary Compensation for Nuclear Damage. This convention not only creates a link between the existing conventions, but also provides an opportunity for states that are not party to any convention to be a party to the convention through the annex, provided they have national legislation reflecting the basic principles of nuclear liability. The modernization that occurred in the 90s has resulted in instruments that provide more compensation for more potential victims as a broader geographical scope. In respect of more types of damage, the heads of damage have been broadened from initially just focusing on loss of life, personal injury, and property damage. They're now broader to reflect the environment and economic forms of economic losses. And also, they provide a greater period of time, 30 years, for victims to claim their damage. And another development was with respect to the jurisdiction. And this development is particularly relevant to coastal states, providing them, if they were a party, with exclusive jurisdiction. So on the one hand, we have a channeling of liability to the operator. On the other, basic principle is also channeling of jurisdiction to the courts of one court of a particular party. These are some of the developments that have occurred. And now, as we look towards the future in the area of nuclear liability, the focus is on pursuing the establishment of a global nuclear liability regime. This was reflected in the action plan on nuclear safety that I mentioned, which addressed the effectiveness of the international legal instruments on nuclear safety, but also it recognized and put emphasis on the need to establish a global nuclear liability regime. What is such a regime? It's one really where there are universal treaty relations among as many states as possible. Currently, there are 5 countries that operate nuclear power plants that are not party to the regime. But of course, there are then a number of other countries that may be neighboring in the vicinity that don't have nuclear installations where this subject of civil liability for nuclear damage can be important. It's important because the regime can provide legal clarity. This clarity is not only something that's needed by the nuclear industry, particularly if we think of newcomer countries and new build projects, but also for potential victims, not only in the country where the accident may happen, but also could be in neighboring countries as well. And I think we're going to perhaps talk on some of these points as we go through to the discussion. I just want to talk about the role of the IAEA. And of course, as a preeminent international organization in the nuclear field, the agency has a central role in the area of nuclear safety, particularly in coordinating international cooperation, in promoting nuclear safety, in providing advice and expertise. And it's not just the Secretariat, but we also rely on the member states to participate in the activities and to share the expertise with other member states. A very important function of the agency is to establish safety standards. And it does this in cooperation with other international organizations. And these are the global reference for what constitutes high levels of safety. These standards, they're not binding. They're binding on the IAEA, but they're not binding per se. They may be binding pursuant to national legislation, and many countries decide to use these standards as a basis for their own regulations. An important standard that I would mention in the context of the international legal framework are the transport regulations. Regulations dealing with the safe transport of radioactive material. These standards, these regulations are incorporated into the UN's bottle regulations as class 7 out of 9 classes of dangerous goods. And they're then also in turn incorporated into various modal regulations, whether it's of the International Maritime Organization as the IMDG code, or in terms of the International Civil Aviation Organization. Through this means they acquire, albeit as a safety standard, non-binding, acquire legally binding force. Standards are also important as they provided the basis, the fundamentals level, the high-level standards for the Convention on Nuclear Safety that I've mentioned, and also for the Joint Convention. Another point I would like to mention with respect to the role of the IAEA is that, yes, states have adopted conventions under the auspices of the agency. The agency is not a party to these conventions, unlike what we've heard about in the area of safeguards, but the conventions, they're the parties' conventions. Some of the conventions prescribe functions for the agency. If we think of the early notification and assistance conventions, there the agency has direct roles with respect to notification and assistance. It also has an important role with respect to coordinating the interagency response pursuant to the conventions. The agency, with respect to the Convention on Nuclear Safety and the Joint Convention, serves as the secretariat for these meetings that I'd mentioned take place on a triennial basis. Also, related to these instruments, we can think in the area of nuclear liability of the Director General's Advisory Group on Nuclear Liability, INLEX, which was established in 2003. And we'll hear from Ben McRae, who is joining this panel's discussion because he's a member of INLEX. And INLEX is there to provide the Director General with authoritative advice on the subject of nuclear liability and the international legal instruments. And of course, I would be remiss of me to forget that there is also INSAC, the International Nuclear Safety Advisory Group, again, another advisory body to the Director General on nuclear safety matters. And we're here joined by Mr. Stephen Burns. I would just like to also mention, with regards to the role of the IAEA, the support in the area of legislative assistance. We have a legislative assistance program which is available to all member states upon request, whether you're big or small, whether you have a large civilian nuclear power program or a small program just benefiting from radiation sources. We're there to provide support in drafting the legislation, whether it's also enacted legislation. We can carry out reviews of this legislation. And as was mentioned by Emily, we also conduct a number of training activities for member states, as well as awareness raising activities for member states. I would just like to mention now, with respect to countries that are considering to introduce nuclear power for the first time, the Director General mentioned this. We have about 30 countries that are considering introducing nuclear power for the first time. We have the United Arab Emirates, who's one of the newcomer countries that has now started operation. And following this country, you have Bangladesh, Turkey, and Egypt that are currently constructing nuclear power plants. A fundamental to the introduction of nuclear power is the commitment to establish relevant the national legal framework to join international legal instruments. And this is reflected in the annual resolutions of the General Conference, the expectations of the community of states vis-a-vis those countries that are considering and working towards introducing nuclear power. The IAEA doesn't make the decisions, doesn't pour concrete, doesn't finance, but we provide advice and support and assistance upon request. And a key focus here is the IAEA's milestones approach to support the development of national nuclear infrastructure. And there are 19 identified issues, and one of those issues is respect to the legal framework. And with respect to the legal framework, one aspect is joining relevant conventions, not just on safety, but in all areas. And you will hear tomorrow with respect to nuclear safety to round off the four branches, nuclear security to round off the four branches of nuclear law. And another key aspect of the milestones approach is also the development of comprehensive national nuclear law, providing a basis for the implementation of the four branches of nuclear law. Finally, mention was also made with regards to developments of advanced technology and small modular reactors and floating nuclear power plants. And there is a lot of work taking place with respect to considering the impact of such advancements with regards to the existing legal frameworks in the safety area, but also in other areas. This week, as I'm sure many of you will know, is the agency's first international conference that the Director General has mentioned. And again, the legal framework will be a big part of the discussions there. Here, there is a need to consider the applicability of the existing international conventions, the adequacy, and then also, of course, the compatibility, because in some aspects, there is a need to consider the maritime law and the law of the sea and the interrelationships between what I've said is nuclear law, and then we have these other related areas of law as well. So in conclusion, nuclear safety and liability are important areas of interest and global concern. The legal frameworks provide a basis to establish the rights and obligations, identification of responsibilities, a basis for international cooperation, and also with respect to accountability when we start to think of civil liability and compensation. The laws are not static. As I mentioned, they have evolved as a response to crises and at the needs and interests of particular the international community. And they need to obviously keep a pace with a broadening interest of new countries joining and introducing nuclear power for the first time, as well as new technologies. With this, I would like to bring this to a close and look forward to the discussion. Thank you.
Join the table and I'll introduce our full panel. Thank you so much. right, well, thank you for those comments, and I'm really looking forward to this panel discussion and the conversation with all of you here. One of the things that I'm delighted about with this group of people is we really have regulatory, legal, and policy for civilian nuclear power wrapped up with this group here, both nationally and globally. And I know I have a lot of questions, and I hope you all do too. Let me introduce our two additional guests here. First, we have the Honorable Stephen Burns, who served as Commissioner of the U.S. Nuclear Regulatory Commission from November 2014 through April 2019. He was the NRC's chairman from January 2015 through January of 2017. And prior to his service as commissioner, he was the head of legal affairs of the Nuclear Energy Agency of the Organization for Economic Cooperation and Development in Paris from 2012 to 2014. He was also a career employee at NRC beginning in 1978, during which he served in a variety of roles, including general counsel of NRC from May of 2009 through April of 2012. He's currently serving as a senior visiting fellow at Third Way in its climate and energy program, and he provides consulting services on nuclear energy law. He was appointed chair of the IAEA's International Nuclear Safety Advisory Group in May of 2022. And a very big moment of pride for GW, he is also one of our law school alums. So very delighted to have you back, and always grateful for your friendship to the law school.
He thought he was going to go into communications law.
I'm also so pleased to introduce Ben McRae, who is the Assistant General Counsel for Nuclear Programs at the Department of Energy, with primary responsibility for providing legal advice and counsel to the offices of nuclear energy, science, and artificial intelligence at DOE. His general scope of legal services include matters like nuclear liability, transportation of nuclear materials, and NRC licensing. Mr. McRae was responsible for development of the department's 2021 Price-Anderson report, whose recommendations were adopted as part of the recent extension of that statute, as well as prior reports, I should note. And Mr. McRae represented the Department of Energy during the negotiation of many of the conventions that we just heard about, including the Convention on Supplementary Compensation for Nuclear Damage, the Convention on Nuclear Safety, and the Joint Convention on the Safe Management of Spent Fuel and the Safe Management of Radioactive Waste. He also holds leadership roles in NEA and IAEA. And I will just say on my personal note here, it was a real pleasure to get to work with Ben when I was at DOE as an appointee. And I knew that I would leave any meetings with Ben both energized and having learned something. So it was always a real pleasure to get to work together, and I'm very delighted to have you here as well. So thank you all so much for being here, and I will come to the table to open it up to questions. And do we have a mic that we're using? Where's the mic? Okay. I'm failing an important test by not seeing a mic on the podium. Oh, thanks. Got it. Okay. This is why I'm a professor. Okay. Thank you. I got it. Wonderful. Thank you so much. Great. Oh, and actually, forgive me, I believe our next order is to have each of you offer some responses to the comments that just came. Then we'll open it up to questions. So could I invite you all? We didn't discuss which order to go in.
I go first. I can go first.
All right.
Yeah, because liability is always the problem. And actually, one of the things I also have known Ben on quite a long time, and we actually, so when I was at NEA, because NEA is the depository for the Paris Convention on Liability, I served as an observer, I guess, technically as an observer on the INLEX committee with, so saw Ben again at that time. So it was an interesting time. So I just thought I'd throw out a couple thoughts, and maybe the first one is I've done some work over the years in terms of looking at the development of the safety regime or whatever. And I wrote an article some years ago about the impact of the major accidents, TMI, Chernobyl, Fukushima, Daiichi. And certainly Chernobyl was the most significant, had the most significant impact because, as Anthony said, you had these 4 conventions, 2 of which came out in such rapid time. I mean, within 6 months, I think you had the was it the notification convention within 6 months? And then, I mean, they were actually, that one was ratified. And then the next one, early next year, but they were basically the same. So the notification convention and then the assistance convention came out extraordinarily soon. It took a little longer for CNS. But one of the things, if you go back and look at some of the literature written about the development of the regime, and as Anthony noted, there weren't really any safety conventions or safety treaties or whatever you want to call them at that point in time. But you will get a certain amount of dialogue and critique regarding this new regime as a toothless regime. That's the words that were used. And that was because it wasn't an inspection and verification program. It was this, let's all get together and huddle and share our stories and things like this. And there was a lot of criticism of that. I would stand back and again, well, actually 94, so can I do the math? What's that, 30 years ago? In 94 was when the CNS came into force, so 30 years ago. And, what would be my perspective of that as both a lawyer, ultimately as a chief regulator at the NRC. And I don't think even though you get some of that message still, I don't think it's quite fair, because I think what we have done with the international regime is we have improved in terms of information sharing, looking at standards, the development, even though they're not binding standards through the IAEA, but they do inform national structures and national bodies. And I think that's extraordinarily important. And again, even with the peer review system, there has been an emphasis on greater transparency over the last few years. I remember Ramsey Jamal, he's still with the Canadian regulator, and was like, for a while there, he was like the temporary head of the agency. And Ramsey, I remember seeing him when I was still on the commission. I think probably was still the chair. And, sort of soliciting, I want you to go around and beat people on the head saying you need to submit, or provide your reports for the CNS in public, which is not required under the convention. But that was another, I think that effort toward greater transparency is another proof of, I think, that within the regime, regulators and others are trying to do their best in terms of improving transparency, but also assuring that safety requirements and the safety objectives are met. Now, having said that, what I think I transitioned to is what are some of the, from my point of view, what are some of the challenges that we have? And we heard Director General Grossi talk about in terms, and others have talked about the development of new technologies, the interest in small modular reactors, what we call advanced reactors, although those advanced reactors, you go back, Fermi 1 was one of those advanced reactors. Fort St. Vrain, with a high temperature gas reactor, was one of those advanced reactors. It doesn't mean that technology hasn't improved or gotten better, but some of these concepts have been out there for quite a long time. But we are seeing more of the development and a lot of interest. You've seen things like the contracts between Amazon and one of the developers. I think it's Kairos And you're seeing things like the restart of TMI-1, potentially, as well as a plant in Michigan, the Palisades plant. So you're seeing this, this growing interest, but you do have challenges, and some of the challenges that I would say are things like greater harmonization across regulatory regimes. Again, because this is a system in which national regulation, national standards are basically the things that shape the deployment of the industry. But there's growing interest in terms of cooperation across national regimes. And a good example is a memorandum of cooperation between the United States and Canada, and now the UK, in terms of sharing information on safety reviews and potential deployment. I always get the name wrong, the BWR, what is it, BWX300. Thank you, Dan. That's the GE Hitachi design. The Canadians are looking at it. The US is looking at it. In Europe, some of these new entrant countries like Estonia are looking at it. So the ability to share that kind of information, even though you still have responsibility as the regulator in your country for making the final decision, being able to draw upon information developed through others, and particularly reliable, seasoned regulatory bodies would be like Canada, the UK, France, and others, is an extraordinary important thing, and I think an area where there will be a lot of focus. This doesn't mean one world regulatory standard, and if we spend our time on that, we'd be wasting our time, because we wouldn't get these new technologies deployed. It has to be the conversation among different regulators about what is important to us. And it doesn't mean that it hasn't been done. There was under NEA auspices the Multinational Design Evaluation Program, which helped particularly in some of the large light water reactors, AP1000, the EPR, the French design, which was also deployed in Finland, was going to be deployed at Calvert Cliffs at one point. So you have that kind of interest. Anthony touched on the new entrant countries. That's an extraordinarily important area for focus. We have the milestones approach. The UAE was sort of the gold star student in terms of its implementation, in terms of its success of deploying 4 large reactors, basically the Korean design. But we're looking at, particularly in Africa and in Eastern Europe, in countries where there hasn't been any nuclear deployment, of that, going down that path. And what that means is there needs to be a lot of international cooperation and assistance, in my view, to help those folks along and to build effective systems, which may be regulatory systems, but also the infrastructure and institutional systems to doing it. And maybe the one last thing I'll mention in terms of areas for focus here is, again, on transparency and engagement with stakeholders. And that is, we were talking a little bit at a lunch or a side conversation about the interest in nuclear, and there is a lot of interest, but there's not always a good understanding. When I came into the system, 40, almost 50 years ago, it was basically, we'll tell you what's going on. Okay, fine. It wasn't a true, in terms of public meetings that our agency had, the NRC, it wasn't as much of an engagement with them. And so you do have, I think, a focus on, when I say transparency or involvement, in terms of sharing understanding, and that's going to be across this, across the spectrum of viewpoints with respect to the deployment of nuclear. But I think it's extraordinarily important. And the last one, and we've seen this in some legislation, the Advance Act now, and the NRC is starting to act on some of the requirements of the act, is there is a real focus on whether there's over-regulation in the system. And the NRC is supposed to recognize that the deployment of nuclear, the benefits of the deployment of nuclear, arguably that's been in the Atomic Energy Act and the Energy Reorganization Act from the beginning, but how the regulator approaches it, that's been one of the critiques. And so now under the Advance Act, the NRC needs to recognize there is the value in deployment of new nuclear. And there's a paper they just issued out, I think it's on the NRC website, issued by the General Counsel for the Commission's consideration. But this is, again, an area where, I think a lot of focus has to be in terms of assuring effective regulation without over-regulation. There was a gentleman, a professor at Harvard Kennedy School, Malcolm Sparrow, wrote a terrific book called The Regulatory Craft. I will say my class entitled the book for, because he said, I'm thinking these two titles, which one? We like The Regulatory Craft. And I've used that phrase myself a lot because I think that's what it is. Where is that sweet spot in terms of good regulation? And that's where I think we have to spend a lot of focus on. Thanks, Ed.
Thank you.
I'll start by saying it was a very sad day at the Office of General Counsel when Emily told us that she was coming back to GW. But those of you in the GW community, you're very lucky to have Emily. She is just a delight and very good. I'm going to try to limit myself to 5 minutes. I'm going to try to do what we sometimes take 2 or 3 days. I'm going to summarize it. I used to work for someone who told me if you can't get a concept down to 1 or 2 words, you're overstating it. I'm going to give you sentences. Why is nuclear liability important? Well, the world needs a lot of clean, secure, affordable energy. There is a consensus that the only way we're going to get there is using nuclear. We've at COP and the Secretary of Energy, any number of people have said we need to triple the amount of nuclear energy in the next few years if we're going to attain our goals. So nuclear has a role to play. Why would you care about nuclear liability? Most people, you talk to nuclear engineers, they go, we just want to build plants. We can do this. And they get very frustrated when they talk to the lawyers. Well, I can tell you, no nuclear project goes forward unless people, the public, the operator, the investor, the lenders, the suppliers, unless they're happy about the way nuclear liability is treated. I am a strong advocate for a global nuclear liability regime based on a treaty called the Convention on Supplementary Compensation for Nuclear Damage. We call it the CSC. The members of the CSC meet on an annual basis. This June, we had a panel of the General Counsel from Westinghouse, the General Counsel from GE Hitachi, the General Counsel from China Nuclear National Corporation, and the senior attorney at EDF for liability. They all agreed on one thing. They spend more time negotiating contracts dealing with the liability provisions. There are a lot of ways to deal with it. Sovereign guarantees, contract provisions, indemnifications. They all agreed that their life would be a whole lot easier if there was a global regime that dealt with nuclear liability. They still would have to deal with it, but it would make life simpler. They can compete on safety, they can compete on economics, but liability is just a nuisance, but it's a very important nuisance. You have to deal with it. That's why we spend so much time on it. from the perspective of law, it actually, I find it a fascinating area. It combines public policy and legal theory. You've heard when the US, we started in 54, we changed the Atomic Energy Act to make it possible for private utilities to build nuclear power plants. Nothing happened. Congress was really annoyed. They had gone to all the trouble to change, and they made major changes to the Atomic Energy Act to let the private sector engage. And nothing happened. They had hearings, and everyone came in. The utilities, the suppliers, the lenders, they all said, liability. We want to build, but we think it's safe, but if there were to be an accident, the liability could be astronomical. We just cannot go forward. They came up with something called the Price-Anderson Act. They went to Yale and Harvard, got the top tort lawyers. Quickly, they came up with a system that works. For the US, we've used it. Nobody worries about liability anymore. It's a kind of complicated system. It was put together quickly. Basically, it requires basically, it makes the operator responsible. It basically requires the operator to have insurance. It then has a pooling where all the other operators will chip in if you exceed the insurance policy. And then if you get beyond that, there are mechanisms for the federal government to step in. Right now, the combination of commercial insurance and the pooling would give you about $16 billion if there were to be an accident. Good system, but as Anthony said, there are international conventions. The West Europeans wanted to develop nuclear in the early 1960s. They saw the issue, need to deal with nuclear liability. They called up the same law professors. They had 3 years to think about it. And they actually were like, how do we deal with these issues? And what they came up with is a much better system. It really is kind of a combination of ultra-hazardous activities, strict liability, but basically they said, we're not going to fight about who caused who was liable, who had intent, who was negligent. We're just going to say, if you operate this facility and it causes nuclear damage, you're going to pay. All the liability is going to be focused on you. That's legal channeling. You're going to have an insurance policy for whatever the minimum amount is. And you're going to focus all the lawsuits in one court, in one country where the accident occurs. It's a very good system that really is the basis. Now, quite honestly, there are a lot of meetings. There are definitions about, not definitions, there are a lot of discussions about what constitutes nuclear damage, what can you compensate. There are issues when we were negotiating, there are issues about law of the sea, there are enforceability of judgments. For lawyers, it's just fascinating if you want to get into the issues. But for the public, it's important. And again, I'll just kind of say, what are the two things we're trying to achieve with a system? One of them is what the catchphrase at DOE these days is energy justice. If you're going to engage in something that benefits the public, but there are hazards involved, you need to be responsible. You need to make sure it's safe. You need to make sure if there's an accident, you respond to it. But at the end of the day, if you cause damage, you need to be responsible for it. I've heard the Director General, because he's a big supporter of the global regime, he will say the primary purpose of any nuclear liability regime is to ensure prompt compensation for the public, for property, and for the environment. That's the most important thing. And again, getting back to, you don't have a nuclear project go forward unless you have public acceptance. And I can tell you, when I first started doing this, they sent me out to talk about Price-Anderson. I thought, is this a smart move? You want me to go out there and talk about there's a nuclear accident? But it's amazing. You talk to people and you tell them, we recognize that we think we're safe. We're doing everything we can. But if something happens, we have something in place. We're thinking ahead. We have a system in place where you will be compensated quickly. That's what happened after TMI. Luckily, there were no releases, but there were evacuations. People got compensated on the spot for their cost of having to move away from their homes. So the system works well. That's what's actually happening in Japan after Fukushima. They've got a very simple, well, not a simple, but they've got a system that gets money to victims. So that's the one way. The other thing is commercial certainty. As I said, you will not get suppliers, you will not get Exim Bank. They will not distribute money to begin the construction of a nuclear power plant until they're satisfied that the nuclear liability concerns are dealt with. They basically require people to be a member of the CSC because they want treaty relations with the US and the country where they're lending the money. But that commercial certainty is important. Projects just don't go forward. I worry sometimes it sounds like all we care about is the industry. That's not the case, but if you want nuclear to go forward, you have to address those concerns. And so that's why it's protecting the public and making it possible for commercial projects to go forward. And with that, I'll finish.
Thank you all so much. And I wonder if I could do my prerogative and ask the first question, which is to ask you all, we've heard about, and I think everybody here is quite aware of nuclear power's role in a clean energy transition and what that means to have this technology that can put out so much power with relatively few life cycle emissions. I wanted to ask about adaptation for power plants. It seems to me that there could be, and certainly my students asked about this last week, what are the implications of major climate disasters for existing plants, whether that's globally or in the US? And to what extent does the liability regime that we have here or the other ones globally account for those kinds of possibilities? So essentially safety issues that arise from major climate disasters.
Well, I think one of the things I would say there is some assessment in terms of existing power plants, for example, in the United States, in terms of what the current assessments, I should say, of the sites, whether there are particular things. I know, for example, there's been a lot of attention to some plants in the state of Florida because, again, the rising seas and things like that. Although when you go back and look at the safety case that was developed in terms of the licensing for the plant, is that it's well within the potential or estimated types of damage or not damage, but maybe sea level rise that you might get. I mean, other types of things that happen, and it can result in a plant having to power down or not operate. I think the French have had some issues in terms of water temperature in rivers and things like that, which can have it can have an impact. Now, again, those are what I'm talking about there are sort of large light water reactors. The question would be, and I will not profess to be an expert on the newer technologies, is whether that you actually that would have the similar impact. Yeah, citing in the terms of, I mean, this is one of the problems with Fukushima, quite honestly, is that there was this whole debate over where the emergency diesel generators, particularly for units 1 to 4, were located, and there had been some ongoing debate about whether they ought to have been moved up or higher on higher ground. Units 5 and 6 at Fukushima Daiichi were not, although I think they lost power. They were able to restart their diesel generators instead of having had them wiped out. It's my recollection. So you do have, and you do have some of those issues that may arise, particularly on existing plants and existing plants that are going into license renewal, or what we call subsequent license renewal. That's license renewal is generally 40 to 60 years, and then potentially 60 to 80 years, which I think was it Turkey Point? Is anybody around the Turkey Point? It just was granted that. So yeah, you're going to have to deal with that. But in terms of citing and those other types of things, basically the safety case that the applicant has to put together and the NRC assesses is going to have to deal with those kinds of issues that might arise, that might be climate related. I don't know if Ben has anything on the liability end.
On liability, the good news, if it's good news, is that the liability regimes would cover that. The liability regimes are designed to basically cover any occurrence that results in the release of radioactivity that causes off-site injury. After Fukushima, there was a debate. There's a trend away from this, but there is the possibility of excluding extraordinary natural occurrences. There was a big debate in Japan and actually in the international community as to whether Fukushima, what came within that exception. It was, depending on who you talk to, it was a once in 1,000 years, once in 10,000, maybe more earthquake. Eventually, the decision was that was not excluded. That was covered by the regime. I think the same thing, even with a Category 5 hurricane, that's not unexpected. Quite honestly, now I wouldn't even think a Category 6, if there was such a thing, would be unexpected. So I think they would be covered. So, again, there would be, but, the truth about Fukushima, the actual damage from the accident was very small. You look at it and it looks like a war zone. That was from the tsunami. Most, the evacuation, some of it was, people were very concerned. There was releases, but most of the damage was from the tsunami and the earthquake. Again, it's been a very the damages from Fukushima are approaching $100 billion. The Japanese are doing incredible technology to deal with the situation. But again, the actual release from Fukushima was very, very small. The only nuclear accident we've ever had where there has been any significant off-site release was Chernobyl, and that was very, very bad.
Yeah, just to add that, of course, the impact of external events is a major part of the siting process for nuclear power plants, and such factors are, of course, taken into account. But then also to bring back to the point about perhaps the toothlessness point, which I don't think you are advocating at all, but at the heart of the Convention on Nuclear Safety and the peer review process, this is the type of issues that provide that opportunity for discussions among the parties, whether it's in the context of topical issues for discussion or whether it's in the context of reporting, and keeping in mind the exchanges that took place as well following the Fukushima accident and the stress tests that were done around the world. So I think that shows also the value of this peer review process. Thank you.
Yeah, and I would just to add on to Anthony's thing, I think that's, if you say that's the hallmark of the Vienna Declaration as well, is that focusing in not only on your obligations under the CNS, but and I can't recite them off the top of my head, but looking at in terms of member states, looking at and assuring you're addressing the overall safety of existing plants as well as assuring high levels of safety for future siting and all.
Great, thanks. Shall we open it up? Group, all right. And we've got a microphone, so if you'll just wait a minute. So we have in the back, and then we have Laura down here. Go ahead in the back there.
Oh, hello. I just want to first thank all the panelists today for coming in. And I had a question. So you talked about like protecting like citizens, and you mentioned bringing in like local stakeholders when talking about these advances in law and technology. And I just wanted to ask, have you guys heard anything of what has been found to be the most effective ways to assuage like public fears over nuclear disasters and effectively communicate these changes in technology and liability laws? And are there any gaps we still need to address in this area?
Well, I think there's always a challenge in terms of doing it. One of the things is that I think, basically the regulatory body has to be out there, but also the company that's potentially citing or citing and operating the facility needs to be out there too, as well. And a lot of them have done fairly, I would say some existing places have done pretty good jobs, because in some respects, what they do is that they may provide additional community assistance. They provide support in, for example, community colleges. There are open, meetings and engagements, and a lot of it has to do with, and I won't profess to be an expert on that, is what are the best ways of stakeholder engagement? It's not having just, we're having a meeting, I'm going to talk to you. Okay, we're done. Have a good day. It's sometimes you have the little, booth, and you go up and talk to people. And so you're individual citizens, as well as you need to engage, I think, local, state governments on things like that. So I think there are a variety of circumstances that will deal with it. I know the NEA, for example, has been, and they've actually formed a special committee or whatever to focus on improved communications and stakeholder engagement and things like that. I will not profess to be an expert on that, but it is terms of you're willing to hear from different points of view. And I know from experience over the years going to public meetings that the NRC would hold, particularly after, there might have been a bad inspection or an incident at some plant, and we go out and you'll get, some people who will just not sit down and shut up. And the problem is you can't just say, sit down and shut up. You're going to have to listen to them to some extent. And, to the extent that they start then blocking others from, engaging, then you've got some problems. But it's just looking at effective means of communication, whether that's in person stuff that's out there, and it can't be just the regulator. It needs to be the company that's going to operate this thing, or is operating the plant.
Yeah, I think part of it is, and this is from the experience of being involved in maybe the biggest failure in the nuclear industry in the US, and maybe the biggest success with respect to nuclear waste. There was a project called Yucca Mountain. We were going to put all our spent fuel in Nevada. We started studying it in the 1980s, maybe back in the 1970s. We did a really good job. We spent billions of dollars on studying it, on preparing a license application. And I may have drank the Kool-Aid, but it was actually a really good application. But basically, the citizens of Nevada felt that they had not been treated fairly. There was legislation, and rather than go through the process of working things out, people decided, we're going to save a year or two. We are down to 3 sites. We're just going to pick one of them. And so they just skipped the last step. We lost the faith of the people in Nevada. We never recovered from that. There was nothing we could do. And we basically, under the Obama administration, we basically decided politically it is not feasible to do Yucca Mountain. And quite honestly, it has cost us billions of dollars, even more. And we don't have. The other thing, though, is the department built something called WIP, a deep geologic repository in New Mexico. There, we worked with the state. It was painful. We involved EPA, but we went through meeting after meeting. We put in, but people thought that we were acting in good faith. And the truth is, once it got started, people just kind of accepted it. But it's getting to that point. But a lot of it is dealing with the public. And as you said, it's a lot of it is just building up that trust. You know, the good news is when I first started doing this, we still had a hangover from TMI. We still had people, most people would go nuclear. They, you know, you always have people who think of mushroom clouds. There seems to be now more people, I can tell with my daughter, I can tell with other people, you know, now they view it as part of climate change. We just need to, that's a bigger concern. And so, but again, a lot of it is basically including people and listening to them. You know, but it's very, public acceptance is one of the hardest things to deal with in the nuclear area.
Thank you. Yeah, I would just say that the basis for such engagement is provided for in the relevant international legal instruments, the safety standards. So there is a strong basis there, but it can present its own challenges. In my experience with regards to supporting countries in drafting their legislation, even on this, in terms of the consultations on the draft laws and the stakeholder consultations and inputs, that itself often presents challenges for some of the member states in that they don't necessarily involve not just the public, but actually all the different agencies and ministries that may have inputs. So this is something that presents a challenge and that we continually to support the member states during the lawmaking process.
I might even just add about WIP, you know, one of the things that makes that so interesting is it wasn't just listening, right? It was actually making design changes to the shipping containers. I think the way the road was routed maybe as well.
Oh, we built
It has all the stories.
Yes, we did a lot. You know, they were all safety related, but we may have built an interstate highway around Santa Fe to deal with concerns about transporting material.
Yeah. So in terms of sort of not just listening, but also seeing where there is room to be responsive, a lot of research shows that also really helps with public acceptance, especially in this kind of area. And even if the engineers don't necessarily agree that that's what's necessary, right? It's the extra amount is sometimes what's necessary to have that public acceptance. Just wanted to add that. Laura, you were waiting.
So thank you all for this incredible overview of the regime for safety, liability, and damage. It's really been an extraordinary overview here. In the morning session on the safeguards regime, we had a little bit of a debate about kind of what happens if there are, you know, gaps or challenges in the regime and there's pressure on it. Is the existing regime adequate to sort of be translated to cover those situations, right? And many people said, yes, it is adequate. But we did have, you know, dissenting view. I'm thinking of Professor David Koplow, who thinks we need new treaties to kind of fill those gaps. I tend to be very skeptical that, you know, new treaties in this moment are possible or a good idea. I think if you open things up, you might get something much, much worse. But my question here for this panel, and this is something that comes up in a lot of different international regimes. With respect to safety, liability, and damage, to the extent that there are gaps, what do you see as the biggest legal gaps? And do you think that the system is adequate to kind of stretch and translate and cover them? I thought the Fukushima example was really interesting, that, this idea that a catastrophic disaster might not be covered, but the decision was made to sort of see it as covered. And that to me shows a kind of flexibility and stretching of the regime. And of course, this regime is particularly complex because it sits at the intersection of international and domestic law. So what do you see as the biggest legal gaps potentially? And can they be dealt with through translation and implementation of the regime? Or do you think there need to be new instruments of some kind?
You want to go?
I'll go on liability.
Yeah.
And there are gaps. I think the principles, in theory, it's a very good system. The legal channeling, strict liability, it's about as good as you get in tort law as far as focusing on compensating damage. To the extent for commercial, the gap on the commercial side is it's not universal yet. And so what you have is where the system applies, then it works. But if you, in Europe, an example, Austria is a concern because the Austrians think they're non-nuclear. They have a research reactor, but they think they're non-nuclear. They don't think they should have to buy into the system. So people worry, what if there's an accident, damage in Austria, you get sued in Austria, you could sue the supplier. It's the reason US companies worry when they do work outside the US, if they don't have treaty relations. If it's in the US, we're covered by Price Anderson. If it's in a country that we have treaty relations, the CSC will channel everything to the operator. But if it's normal tort law, you're looking at decades of litigation against suppliers, investors. That concerns them. We didn't have treaty relations with Japan at the time of Fukushima. There was 10 years of litigation just on whether US courts would take jurisdiction. And eventually they decided there was an adequate remedy in Japan. And that you would think that's good news. You could not do more than the Japanese are doing to compensate damage. They compensate everything. It took 10 years to decide that that was adequate. The industry is not at all convinced that that would always be the case. So that's one. So we need a global regime to address that. We need to and we're working on that. The other is from the environmental justice point of view. The system is really great about getting compensation to people promptly, without litigation, but before we updated the conventions, the liability amount in the Paris Convention was $5 million. Now, I assume that things were cheaper in the 1960s, but it's hard for me to imagine that $5 million was ever thought to be adequate. But, that's not going to convince people that the system works. Do we need a new regime? I can tell you, we went over this issue. The US advocated when we were negotiating in the 1990s for amount $1 billion, $2 billion. Easy for us because even at that time, our amount was close to 10 billion. So but we are by far the exception. Most countries think that they're doing really well if they have $1 billion in liability. It was like pulling teeth to get the international community to come up to 300 million special drawing rights, which is about $500 million US. And that reflects the amount of commercial insurance available then. So again, I'm not sure redoing. What we do is we advocate to countries, you need to increase, yes, you could limit it to 300 million, but you really ought to go see how much insurance. Right now, I think you can probably get $1 billion in insurance. In the US we've got 100 plants to repool, but there are ways of dealing with this. The Japanese, the way they're financing this is they basically have put the money up front and they have told industry, we're going to charge you a small amount each year that you will put on the rate base. And you will pay us back $100 billion, but it's going to take 50 years. And it will be, there are ways to deal with this. But again, I'm not sure it's renegotiating the treaties, but those to me are the two gaps that I would see.
Thank you. It's a really interesting question. I think it's also one that, was considered following the Fukushima accident as well, whether there was a need to reconsider the international legal framework, whether it concerned the role of the IAEA, establishing non-binding standards, the peer reviews, advisory services are upon request. They're not like the inspections that you heard of in safeguards. Is the peer review mechanism of the CNS and the Joint Convention enough? Or should we start again and create a new system? In an ideal world, perhaps, but in reality, it's not possible to pursue that path. And I think what's been demonstrated through the strengthening of the effectiveness of what exists, the existing conventions, through different means to strengthen the operationalization of those instruments, whether it's on emergency preparedness and response. These are framework conventions, the early notification and assistance conventions. Underneath them are operational arrangements that are established by the competent authorities identified pursuant to the conventions, the Secretariat. These are the flexible operational arrangements. So they're more fluid, and they're what can be adapted and create flexibility. The same, you could say, with respect to the peer review process as well. The parties have strengthened the peer review mechanism, improved and enhanced, for example, with respect to transparency, the sharing of reports, even with regards to the IAEA's own peer reviews services. These, as I mentioned, are upon request, and what you've seen is increasing utilization of these missions, and also further to the action plan, that there is enhanced transparency with respect to the reports, because they will be made available 90 days after the mission unless the state says otherwise. So I think within that way of thinking, that there is flexibility within the regime. When we think of new technology, for example, the Convention on Nuclear Safety applies to land-based nuclear power plants. Already in 2015, the parties had, in the context of their review meeting, discussions, and they amended the guidelines on national reporting for the national reports, where not only do you need to provide information on implementation of land-based, but they provided this flexibility for other reactors, which could then perhaps bring in non-land-based nuclear power plants. Already before, parties were already reporting on research reactors, but there were discussions because of this interest in floating nuclear power plants, perhaps non-land-based, and they provided that flexibility. So in following this approach, even though strictly speaking, the definition is couched in the way it is, it's land-based, they've provided the flexibility for reporting on the implementation, on the safety of other types of reactors. And I think that's an important point, because if everybody follows that path, when eventually we may see an uptake of such non-land-based, well, I think that's a good way forward. And then perhaps in the future to see whether or not there is a need to further strengthen the convention legally to amend it with respect to the definition. Thank you.
Yeah, I would align myself with Anthony's comments. Again, right now, I don't see it so much, given the context of the regime, that there is something glaring, missing, whatever, as he notes on floating or transportable nuclear power plants. That's kind of the issue. And then the DG has also initiated this Atlas initiative with respect, that's for, basically commercial type shipping, it's more on the shipping end. But again, I think a lot of what it is, particularly on the safety side, is really, are we getting what we need out of the peer review processes? That's both under the conventions, also the things like the IRS missions that the IAEA does. That's assessment of regulators. And for example, I think the one that was done in Japan before Fukushima identified some issues, which just Japan didn't deal with. And if you look at, for example, the official diet report on the Fukushima disaster or accident, it says that this was a man-made disaster, not a natural disaster, because it was basically the ineffectiveness of industry, government, and the regulator in terms of meeting their responsibilities. So that's where, from my standpoint, you have to sort of keep focus. And, there are various issues. One of the things we've had, even like in the inside discussion, some are discussing, not saying that the peer review meetings of the CNS are ineffective or whatever, but it says, are we getting enough out of them? I mean, is there some, and I'm not even quite sure, because we just started that discussion, where it's going to go. But the idea is, could we be, are we doing something more than sort of rote reporting and things like that? And I leave that to others to come to that kind of conclusion, if there are ways of particularly enhancing the system.
Maybe just to add on what you said, I think a challenge there is with respect to that peer review process, when you have now 96 contracting parties, and we have 31 countries operating nuclear power plants. All but one is not party. So that's 66 other countries that don't operate nuclear power plants, but they're party. And there are good reasons, perhaps, for them to be party. They want to perhaps introduce nuclear power. So this is the opportunity to already start developing and learning and understanding what's required when it comes to matters of nuclear safety and regulation of a sophisticated technology. But I think that's also a challenging area then, to have the effectiveness of these processes when we're pursuing increasing adherence to international legal instruments, because we want to have countries embrace the conventions. But of course, then we need to have in mind, and the parties, I should say, more so than myself, but the contracting parties to the conventions, the effectiveness of their review systems as well.
A question over here for sure. Can I help with the?
Thank you. I'm Sharon Squassoni. I teach at the Elliott School of International Affairs. Mr. Burns, I'm glad you really brought up the fact that the peer reviews of Japan's nuclear operations were not heeded by the Japanese. And in fact, I had some interesting calls with some vendors who had built those reactors in the days following Fukushima, who said, even that industry to industry conversation didn't result in much. So forgive me if I'm a little skeptical of the voluntary. I agree that peer reviews do enhance transparency, but sometimes they don't get you what you want. I think most industry folks in the US would say by far the thing that makes our industry the safest is IMPO, right? Because there are the Institute for Nuclear Power Operations where the actual operators police, I don't want to say they police themselves, but they have created a culture of safety and there are real consequences for bad reviews, right? Some CEOs have been demoted, et cetera. It's okay. So this is a question you may not be able to answer the panel, but I'm going to ask it anyway. One of the things that concerns me about the enthusiasm for these new, SMRs, which most of which are paper reactors, is that the idea to make all of this work, right, to triple nuclear energy is you're going to have to build a lot of reactors. And one of the objectives there is we're not just going to make reactors for electricity, we're going to make them for a whole bunch of other different industrial applications and across the board. Okay. You're going to have different organizations and outfits running those nuclear power reactors, the SMRs, right? So then what happens to our IMPO system? You're not going to have a very homogeneous sort of operation of nuclear power plants. So I know that question is really far out there, but I think it's worth thinking about in the same way, and this is my second question, a follow-up on Emily's, this thing about climate change, right? I get it, water rise, somewhat predictable. And of course, we would have taken that into account when you're citing nuclear power plants. But how much of our weather now is really all that predictable? I mean, the thing about climate change, right, is that there are going to be some as the system heats up, there will be many more unpredictable things. And how does that, for example, affect the liability considerations? Thanks.
Well, I think it's an interesting point with respect to sort of the sort of industry interaction, because it's true. I mean, IMPO came out of TMI. And there was a great book, I think it may have been a PhD thesis called Hostages of Each Other in the early 90s about the founding of IMPO. And that, that goes back to, I remember a phrase, even from my boyhood about, an accident one place is an accident every place. And there's still, I think, something to that. What I would say I don't have a good appreciation of is in terms of how the industry, say through NEI or other organizations are looking at that. But ultimately, whether you're going to stick the reactor there to produce hydrogen or district heating, which some of, even some of the early ones were thought to be potentially doing those types of things. There are identifiable responsible parties, and not my guess, but I would imagine that you would probably have some incentive for them to sort of get together. I can't say that's a guarantee. I'm not saying that. But ultimately, will have to be qualified. Whoever is, quote, the operator will have to be qualified and licensed to, operate that reactor at that site. Whether it's an SMR, the other one is the micro reactors that are basically, I'm actually on a board of a company that's developing those in terms of, as replacements for diesel generators and sort of, remote sited type things. And again, there's a responsibility that they're going to have what may be interesting, and I'll certainly let Ben speak to that, or Anthony as well, in terms of the liability regime, is to what extent, where do they get, are they within that regime or not? And then you also then, it's the question of what's the safety impact, what's the maximum credible accident, as we used to call it. In terms of the, the ultimate safety or impact of, an event with adverse consequences. So, yeah, it's an interesting question. I think will be interesting as it sort of develops along. And with the other one, I mean, apart from IMPO, there's also the World Association of Nuclear Operators, and I'm not sure, I don't know enough about to what extent they're starting to look at that or not. Ben?
Oh, I'm willing to talk about anything. So, and a disclaimer, I am not a policy person at DOE, and these are just my views. But I do think after Fukushima, I spent a fair amount of time in Japan dealing with liability issues. And the Japanese, their response was remarkable. There were people working all night long. They turned out the lights and the air conditioning because they shut down all the nuclear plants, so they didn't have power, but they kept working. And they've done a really remarkable job. But one thing that struck me is there were a number of people who you could tell, even after the accident occurred, the attitude was, we couldn't have a nuclear accident. This didn't happen. I mean, literally, it was like they could not comprehend that because they were complacent or they just, as you said, people, and now I'll say NRC, our industry, the safety culture is remarkable. People really do care, but I can understand the question of, okay, we're going to build an SMR and put it next to a industrial plant, and we're going to have somebody sitting in a booth, one person or whatever, operating it because it's so good. You don't need it. Again, is that a concern? Yeah. Again, it's weighing. I mean, I really am afraid of climate change. I really think we have to deal with it. And I do think nuclear I also kind of buy into that there's a difference between a big nuclear power plant and an SMR. I don't want to say that a nuclear accident is a good thing, but again, it gets into the amount of radiation released into the atmosphere and how far it's spread. It's harder to do that with a research reactor, with an SMR. Again, it's weighing the risk. But again, when I started out, I worked for a law firm that represented the United Mine Workers. I would look through all kinds of case files of people who worked in coal mines, there were a lot of people who died and had from the fossil industry. Again, we needed coal. But again, it's a trade-off on the risks. So it's a good question. We're going to have to deal with it. I don't know. As I said, NRC does a remarkably good job on developing the safety. At DOE, we have a little bit tougher. Our people are very good. They have safety culture, all of that. We just don't have cookie cutter facilities. We have research labs, we have research reactors, we have reactors, I don't even know what they call them, but we just have a lot of different nuclear activity. But it makes it more challenging because you have to develop the safety plan, you have to look at that. You can't just say, this is what I'm going to do. You have to, again, but it is going, I think it's going to happen. I think we're going to have SMRs deployed, and we're going to have to come up with a way of dealing with it to make sure that they are safe.
Anthony, and this may be the last word. Let's see.
I wouldn't like to be the one to do that, but just to say, I think with any new entrants that are coming in, whether it's designers, whether it's operators, whether it's states themselves and their regulatory bodies, need to be brought into this nuclear world, understanding the requirements that are involved, the infrastructure that's needed. I don't think we want to have a lowering of the standard of safety that we currently have today. Maybe some requirements may not be needed given the designs, the passive safety features, the smaller source term, perhaps on liability. There's consideration and discussions about the amounts. But I think really this is the focus, to try and bring in all new players and have them understand the aspects of safety and also civil liability if we're going to move forward with nuclear technology and its contribution, particularly for climate change, economic development, energy security.
All right. Well, shall we do a transition here for, let me first, before we make a transition, thank you all so much. This has been a terrific conversation. Have really enjoyed the engagement from all of you, and just want to invite everybody to help me think. So I think next we have closing remarks from my fantastic colleagues, Laura Dickinson and Rosa Solorio. So we'll take just a couple of minutes to switch out.
Okay.
So it has really been an extraordinary day. We've had a discussion of the IAEA safeguards regime, the regime for safety, liability, and damage. We've talked about the challenges facing these regimes. We had the extraordinary keynote and dialogue with the IAEA Director General Grossi, where he is literally traveling the world promoting nuclear safety and security, coming under fire in Ukraine to safeguard those nuclear reactors, coming up with principles to provide greater security for nuclear facilities in war zones, dealing with proliferation, the risk of proliferation in the Middle East, the reality of proliferation in the DPRK, and promoting the value of nuclear in a safe way to deal with climate change, economic development, and so much more. I think this is precisely the sort of convening role that universities should play in helping move important discussions along in partnership with international organizations and others, both in and out of government. And I want to thank you. I want to thank you for coming. I want to thank our speakers. I want to thank our partners at GW, our partner universities. Above all, I want to thank the IAEA. I believe it was the vision of Director General Grossi to do this event, partnership with all three schools. I want to thank Perry Lynn Johnson for running with that vision and making it happen. And I also want to thank I want to give a very special thanks to two people who are the real force, perhaps the nuclear force in a good sense, behind this event. And they are my colleague, Professor Leah Calabro, and also our program associate, Yingzi Dai. And I just want to say, and I do want to give them a round of applause, I just want to say that to put on an event like this requires incredible work, both substantively, logistically, attentiveness to the big picture, and every tiny detail. And so please join me in thanking them for making this event happen. And finally, I want to bring to the podium my dear colleague, Rosa Solorio, the Dean of our International Comparative Law program, and also the Burnett Family Distinguished Professorial Lecturer in International and Comparative Law and Policy.
Well, first of all, good afternoon. It's been such a joy being here and hearing all these discussions throughout the day. And on behalf of our International and Comparative Law program, I want to thank all of the speakers and all the moderators today for sharing with us your insight, experience, and wisdom. We take very seriously at the law school our role of getting together and convening all these actors in international law to discuss the challenges of our time. We consider nuclear non-proliferation, also nuclear safety issues as a priority in international affairs today. And we have witnessed today an amazing set of conversations and reflections on challenges and advances in this area and the path forward, which is very difficult in this area. I have a lot of thank yous. You know, this kind of event, as Laura indicated and Professor Dickinson indicated, is very difficult to put together, is very large, but it's so wonderful to see it come to fruition and successfully today. I want to thank all the organizations that co-hosted this event, including the International Atomic Energy Agency, Georgetown University Law School, and American University Law School. I also want to give an important shout out to all the GW University institutions that were and worked and collaborated to put together this event, including the GW Law programs on national security, cybersecurity, and foreign relations law, the environmental and energy law program, also our program, International and Comparative Law, but also the George Washington University Alliance for Sustainable Future. I want to thank Professor Dickinson for her leadership in putting together this event and for constantly bringing to our law school important conversations on priority issues at the global, regional, and national levels. We're really lucky to have her as a faculty member in this institution. And I just want to share my deep gratitude and deep recognition, actually, for people that are not only here in the room, but people that are not in the room that had a lot to do with this event. So deep recognition and gratitude to Lisa Skank, to Donna Atanasio, who's here, to Leah Calabro, to Jinxie Dai, to Dorothy Anderson. Without all of them, this event would not have been possible. And thank you so much, for joining us at the law school. And we hope that this is actually the start of a conversation. We hope we continue collaborating in the future. Thank you again.